This opens up the possibility of shell companies being set up for the sole purpose of making donations to political parties with no other business of consequence having disbursable profits. So the Election Commission had pointed this out, that look, you are doing this, but this will open up the gates to shell companies being used to donate money to political parties. My lord, this is not correct, because you can't, citizen can't do this, match the following, etc. Because the company does not disclose who they have given the bond to. Company only discloses the total bonds purchased. The political parties only discloses the total bonds received. So you can't, no citizen can match. Only the government, only the state bank, only the state bank. State bank and any law enforcement agency which asks such information from the state bank. Strictly speaking, only that. Otherwise, citizens certainly can't. It completely defeats the citizens' rights. Now, my lord, I just want to read out the objections of the Election Commission. Para 25. When this bond scheme was introduced, the Election Commission as well as the Reserve Bank strongly objected to it. Here, my lord, it makes no difference in my respectful submission, because the political party earlier said that we have received X crores from 20,000 or less. Now they'll say we have received the same X crores from 2,000 or less. If they don't want to disclose those cash donations, they don't have to. So it's not going to make any substantial difference whether the limit is 20,000 or 2,000. Then, my lord, Companies Act. Certain amendments have been proposed to Section 182 of the Companies Act, where the first proviso has been omitted, and consequently the limit of 7.5% of the average net profits in the preceding 3 financial years on contributions by companies has been removed from the statute. This opens up the possibility of shell companies being set up for the sole purpose of making donations to political parties with no other business of consequence having disbursable profits. So the Election Commission had pointed this out, that look, you are doing this, but this will open up the gates to shell companies being used to donate money to political parties. As I said, my lord, what could be happening is that, let's say, I mean, one of the allegations in that Adani matter is that the money which was siphoned out by over invoicing to companies which are registered in tax havens was thereafter funneled into these companies. Now, suppose, my lord, that money is now funneled through a subsidiary to political parties. That's really black money. It's really black money and in a way foreign money, which is coming to political parties through these shell companies which have been set up as subsidiaries.
Now, Mr. Bhushan, we go straight to your formulation now.
Yes.
I think we've seen the scheme, we've seen the
RBI reply.
RBI reply perhaps to make sure, so that they now can formulate, so then we can go to Mr. Sabali.
Now, just, my lord, just the RBI letter and the government's reply under on this. They said, no, government said, not RTI. Government in Parliament said.
Let us see that.
Yes, page 489.
Volume 4?
Volume 4, page 489. They were asked whether you have received any concern from the Election Commission, and they said no. Page 489. Will the Minister of Finance please be pleased to state, question D, whether it is a fact that the Election Commission has raised concerns on the issue of electoral bonds? If so, details as well as reasons thereof. Now see the answer to question D at page 490. The government has not received any concerns from the Election Commission on the issue of electoral bonds. I mean, they treat this so casually. You can just say whatever you want and get away with it. And the RBI's objection is at page 437.
Which is that government has not received it.
Of the same volume. Document number 29.
No, foreign funding, probably. This is mainly on account of foreign funding or otherwise?
No, this is 30th January 2017, letter by the RBI,
What page is that, Mr.
page
Bhushan?
437 of volume 4. Document 37, what's that?
Yeah.
29.
29.
29.
This only talks about.
Please refer to your email dated January 28, 2017, forwarding a proposal to amend Section 31 of the RBI Act so as to enable scheduled banks to issue electoral bonds as a mode of donation to registered political parties. We have examined the proposal and our views are as follows. 1. The move will result in multiple non-sovereign entities being authorized to issue bearer instruments. As such, the proposed mechanism militates against the RBI's sole authority for issuing bearer instruments, that is cash. Bearer instruments have the potential to become currency and if issued in sizable quantities can undermine the faith in banknotes issued by the central bank. Amending 31 would seriously undermine a core principle of central banking legislation and so would set a bad precedent. 2. Even the intended purpose of transparency may not be achievable as the original buyer of the instrument need not be the actual contributor to the political party. The bonds are bearer bonds and are transferable by delivery. Hence, who finally and actually contributes the bond to the political party will not be known. 3. While the person buying the bearer bond will be as per KYC parameters, the identities of the intervening persons will not be known. Thus, principles and the spirit of PMLA Act will get affected. 4. If it is the intention that the person entity buying such bond is expected to tender it to a political party, such intention can be accomplished today by a normal check, demand draft, or any other electronic or digital mode of payment. There is no special need for or advantage by creation of an electoral bearer bond, and that too by disturbing the established international practice. We are therefore of the opinion that it will not be advisable to amend Section 31 of the RBI Act just for the sake of providing a formal mechanism to persons, entities contributing to political parties when existing banking instruments such as checks, drafts, digital mode can equally be achieving the said purpose and objective. Now, my lord, I'll come back to my my legal submissions. I have in my written submission, I am not reading that. I have quoted several letters of the RBI. I don't need to, your lordship can go through it. I'm just for the interest of time. Now, my grounds for challenge, my lord, page 23. First ground is that it violates the citizens' right to information about funding of political parties. That, my lord, I have quoted Anjali Bharadwaj, recent judgment of this court in the case of information commissions. First, my lord, para 39. Right to information has been held to be part of the fundamental right of freedom of speech and expression in terms of 19(1)(a) and 21 of the Constitution. Political parties hold a very important constitutional status, explained above, having significant powers in the form of decisive control over the formation of central state governments, voting by MPs and MLAs, passage, non-passage of important bills in state assemblies, for the purpose of properly giving effect to the citizens' right to information about political parties, including voters' one other thing that is that political parties are given a common symbol. So therefore, political parties are part of the instrumentalities of the state, and this has been held by this court. And even the CIC has held that political parties are public authorities under the Right to Information Act. For the purpose of properly giving effect to the right of citizens to have information about political parties, including voters' fundamental rights, information about who all have donated to a particular political party is an essential information for the common people. Without any knowledge of which political party is being funded by which corporate house / individuals and whether policies are being carved in favor of such corporate entities, a citizen is bereft of critical information.